You're driving down the interstate, maybe the radio's playing, and you pass one of those big, colorful welcome signs. And in that exact fraction of a second, right as your tires cross that invisible geographic line, you kind of have to wonder if your legal status in the U.S. just suddenly downgraded. Like, are you suddenly a second-class citizen just because your license plate is a different color?
It is wild to think about because, we mostly treat crossing a state line today as just a geographic novelty, like, oh, the speed limit changed or the roads got a little bumpier. But historically, before the U.S. Constitution was ratified, crossing a border was literally like entering a foreign country.
Right, a totally different vibe.
Exactly. I mean, during the era of the Articles of Confederation, states were engaged in these really bitter trade wars. New York was actually taxing firewood coming in from Connecticut and cabbages from New Jersey. States were actively treating each other's citizens as hostile foreigners.
Which is just crazy to picture today.
Yeah, and it completely crippled the national economy at the time. It really threatened to fracture the young country before it even got started.
Well, that historical chaos is actually the perfect starting point for our mission today. So, welcome to the deep dive. We are unpacking a stack of legal mastery guides today. Specifically, we're looking at MBE Constitutional Law Prep and the MBE Legal Mastery Guide.
And there's a lot of really fascinating material in there.
Oh, absolutely. Our goal is to explore a surprisingly relatable topic. We want to look at how the U.S. Constitution actually prevents states from, reverting to those cabbage taxing days and treating out-of-staters or new arrivals like second-class citizens.
It really is a profound area of law because it gets right to the core mechanism of American federalism. It asks what it actually means to be a citizen of a unified single nation, rather than just, a resident of a specific isolated state.
Right, because the founders had to build this legal architecture that forced these super independent-minded states to basically play nice and allow free movement. And for you listening, whether you travel out of state for work, or maybe you're planning a massive cross-country move, or you're just trying to understand your fundamental rights as an American navigating across state lines, these rules dictate what states can and cannot charge you, or even outright deny you. So, okay, let's unpack this.
Let's do it.
We have two distinct but heavily overlapping legal doctrines on the table today from our sources. We've got Article 4 privileges and immunities, and the right to travel.
Yeah, and they often travel together in legal arguments, but they serve very different functions and protect entirely different groups. Before we can even talk about what rights are protected when you cross that border, we really have to establish who exactly gets the constitutional VIP pass.
Oh, so the rules change depending on who or what is crossing the line.
Completely. The rules of engagement change entirely depending on the nature of the entity trying to cross the state line.
So before we get into the specific rights, we really need to know who gets to walk through the door in the first place.
Exactly. And this brings us to Article 4, privileges and immunities. The actual text of the Constitution says that the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states.
Which sounds very official and grand.
It does, yeah, but the core philosophy here is just interstate equality. It's a direct reaction to those early trade wars we talked about. Basically, a state cannot discriminate against citizens of other states in fundamental matters.
Okay, that makes sense.
But there is a massive trap in the legal guides we're looking at. And the trap is that Article 4 only protects natural person citizens.
Wait, natural person citizens, meaning like actual human beings, flesh and blood.
Yes, exactly. It does absolutely nothing for corporations. And as a general rule, under the specific clause anyway, it doesn't protect aliens either. It is strictly about one state's human citizens being treated unfairly by another state.
Wow, okay.
The historical reasoning here is that a corporation is not a naturally occurring entity with inherent human rights, It is an artificial creation of a specific state's laws. So if Delaware creates an LLC, Maryland has no constitutional obligation under Article 4 to treat that Delaware creation with the same fundamental dignity it affords to visiting human beings.
Okay, so Article 4 is strictly a human-only bouncer.
That's a great way to put it.
Like if a business tries to get in, they get turned away at the door, the bouncer checks the ID, sees it's an LLC or a corporation, and just points them straight to the exit.
Right. No entry for you.
But wait, if a corporation gets hit with a massive, discriminatory out-of-state fee like, say, a state decides to charge double to any freight company shipping goods from across the border, are they just out of luck? Can states just bully out-of-state businesses with impunity?
Not exactly. They aren't out of luck, but they would have to look to a completely different legal doctrine. They would rely on the Dormant Commerce Clause.
Ah, the Dormant Commerce Clause.
Yeah, which protects against state burdens on interstate commerce. The Dormant Commerce Clause doesn't care if you are a human, a corporation, or an LLC. It only cares about the free flow of trade.
That makes sense.
We are going to untangle how those two distinct doctrines collide a little later because the overlap is really where states try to find loopholes. But just remember, for the shield of Article 4 to apply, you absolutely must be a human being.
Okay, so we've established that you are protected as a human visitor. But protected from what exactly? I mean, this can't mean a state is forbidden from ever charging an out-of-state or more for anything, right?
Yeah.
Because I am pretty sure out-of-state college tuition is a very real, very expensive reality for a lot of people listening.
Oh, definitely. And what's fascinating here is how the courts have drawn a really sharp line. It actually traces back to an incredibly influential 19th century case called Corfield v. Coriell.
Okay, what happened there?
Well, Justice Bushrod Washington laid out that Article 4 doesn't just blanket protect every single preference or perk you might want when you visit a new state. It only protects, quote, fundamental rights tied to national citizenship.
So not everything makes the cut.
Right. In modern legal terms, it essentially distinguishes between your livelihood and your leisure.
Livelihood versus leisure.
Yeah.
Okay, let's put some concrete examples to that so we can see how the courts actually apply it.
Sure. So a classic livelihood hypothetical from the prep guides involves professional licensing. Imagine a state charges a resident lawyer, or maybe a resident doctor, a $500 annual licensing fee.
Okay, $500, standard fee.
Right. But then they charge a non-resident, like someone living just across the border who commutes in to practice, they charge them a $5,000 fee.
Oh, wow, 10 times as much.
Exactly. Practicing law, medicine, or even something like commercial plumbing is considered the pursuit of a common calling. It's your livelihood. Economic survival is a fundamental right heavily protected under Article 4.
So the state can't do that.
No, the state generally cannot impose that kind of aggressively discriminatory fee.
Because if states could do that, we'd go right back to the 1780s, where states just legislated out-of-state competitors out of existence just to protect their own local workers.
Exactly the fear the founders had. But now, contrast that economic protection with leisure.
Okay, how does leisure work?
Say a state charges a resident $50 for a recreational elk hunting permit, but they charge an out-of-stater $200. Or consider access to state-owned parks or, recreational fishing.
Right, vacation stuff.
Yeah. Recreational hunting is a use of the state's natural resources for amusement. It is not a fundamental civil or economic right. The Constitution does not view a cheap vacation as a fundamental aspect of national citizenship.
So leisure gets thrown out.
Basically, yeah. It receives much weaker protection. The state is usually totally allowed to charge non-residents a premium for those recreational activities.
Okay, so the Constitution cares deeply about my ability to make a living and access the courts. Like, if a state tried to charge me triple for a civil lawsuit filing fee, Article 4 would step in.
Yes, absolutely. Access to courts is protected.
But it really doesn't care if I had to pay 4 times as much to catch a trout on my weekend getaway.
Spot on. And there is also a major exception regarding political functions. Voting in state elections or holding state elective office can be legally restricted entirely to residents.
Oh, interesting.
Yeah, you cannot live in New York, own a vacation home in Florida, and then demand the right to vote for Florida's governor under Article 4. Political rights are fundamentally tied to the community you actually reside in, not the ones you merely visit.
You know, I'm struggling to see how a state ever loses an Article 4 challenge then. I mean, if a state is highly motivated to protect its own local economy, couldn't they just invent a seemingly valid reason for the discrimination?
What do you mean?
Well, if we look at a livelihood like commercial fishing, not recreational, but like actually making a living, couldn't a state just ban out-of-state fishers and claim, well, our local ecosystem is collapsing, so we have to ban outsiders to save the fish? That sounds like a perfectly valid excuse to get rid of competition.
That is a great hypothetical, and you've just hit on the state's primary defense strategy and why the courts require them to pass a really rigorous standard called the substantial reason plus close relationship test.
Okay, that sounds intense.
It is. The state must show a real important justification for treating non-residents differently, like a collapsing local ecosystem. But that is only part one. The close relationship prong is where states usually fail.
Why do they fail there?
Because they have to prove, with actual data and evidence, that non-residents are the specific source of the problem they are trying to solve, and that the discrimination is tightly linked to solving it.
Ah, So they can't just use outsiders as a convenient scapegoat.
Exactly. If resident fishers are depleting the waters using the exact same methods and at the exact same volume as out-of-state fishers, the state cannot just ban the outsiders.
The court would see right through that.
They do. The court looks at that and says, your problem is overfishing, not out-of-state overfishing. If the locals are equally to blame, banning only the non-residents is just naked economic protectionism, and the law would be struck down under Article 4.
Okay, so since states know this test is incredibly hard to pass, they must look for other ways to favor their own residents without tripping the Article 4 alarm. Which brings us to the overlap you mentioned earlier. Here's where it gets really interesting.
Yes, the intersection of Article 4 and the Dormant Commerce Clause.
Right, where the human protections of Article 4 collide with the business protections of the DCC.
The legal mastery guides warn students that this intersection is incredibly tricky. These two doctrines frequently overlap, but they have completely different blind spots and exceptions. The most glaring difference is how they treat a state when the state is spending its own money.
Okay, let's put them side by side, using the hypothetical from the sources about a city-funded construction project. Let's say a city passes a local ordinance that says, if we are paying for this new library with city taxpayer funds, 100% of the construction workers hired by the contractor must be residents of this city.
Okay, so if a large, out-of-state construction contractor challenges this local hiring mandate under the Dormant Commerce Clause, arguing that it burdens interstate commerce?
Which it definitely seems to do.
Right, but the city has a silver bullet defense. It is called the market participant exception. The DCC generally prevents states from regulating private markets to favor locals. But if the state or city is acting as a buyer, a seller, or a participant in the market spending its own taxpayer money, the DCC does not apply.
Wow. Really? So they can just discriminate?
Under the DCC, yes. The philosophical reasoning is that state taxpayers funded the public treasury, so those taxpayers have a right to reap the primary economic benefits of their own taxes.
Oh, it's like having two security systems on your house. The city might completely bypass the Dormant Commerce Clause motion detector because it's spending its own money, so the motion detector just ignores them. But they still trip the Article 4 window alarm.
That is a perfect analogy. And when that window alarm trips, the human worker who is turned away at the construction site has a direct path to sue. Article 4 has absolutely no market participant exception.
Zero exceptions for spending their own money.
None. The human worker, the natural person from out of state who is denied a job pursuing their common calling, can sue under Article 4 and likely win, because the city is discriminating against a non-resident's livelihood.
So the city's defense saves them from the corporate contractor's DCC lawsuit, but leaves them completely exposed to the individual human's Article 4 lawsuit.
Exactly.
Are there other blind spots where one doctrine works but the other fails? Like, what about the federal government's role in all of this?
The role of Congress is the other massive difference. Congress has the ultimate constitutional power to regulate interstate commerce. Because of that, Congress can actually authorize states to burden interstate commerce.
Wait, they can just give permission?
Yes. If Congress passes a federal law explicitly saying states are hereby allowed to tax out-of-state freight companies at a 20% higher rate, then the Dormant Commerce Clause issue vanishes entirely. Congress gave the state permission to be protectionist.
Okay, let me guess. Congress cannot give a state permission to violate Article 4 human rights.
You nailed it. Congress absolutely cannot authorize a state to violate individual civil rights under Article 4. Even if Congress unanimously passed a law saying a state could charge non-resident human lawyers 10 times more for a legal license, the Constitution still forbids it.
Wow, so it's untouchable.
Pretty much. Article 4 is an absolute fundamental individual protection that even the federal government cannot waive on a state's behalf.
So far, everything we have discussed focuses entirely on out-of-staters who are, visiting, commuting, or doing business across a border. But what happens when the visitor decides not to leave? I mean, the moment you unpack your moving boxes and change your license plate, Article 4 stops being your main shield, and a completely different constitutional gear engages.
Right, and this is where we transition to the second major doctrine in our sources, the right to travel.
The right to travel.
Yeah, because once you intend to stay, you are no longer an out-of-stater seeking privileges. You are a new resident seeking equality.
The right to travel sounds like It's just about the physical act of driving on the highway, but the sources frame it as something much deeper about how a state treats its newest neighbors.
Yeah, it definitely is deeper. It actually has three components. First is the literal right to move from state to state. Like, states cannot build walls or close their borders.
Right, no internal passports.
Yeah, exactly. Second is the right to be a welcome visitor, which heavily overlaps with the Article 4 concepts we just covered. But the third and legally most combative component is the right of new residents to be treated equally to native-born, long-term residents.
Equality for the new folks.
Right, and this was famously solidified in modern law by a Supreme Court case called Science v. Roe.
This seems like the area where the most friction happens, though, because states generally want to protect their social safety nets and public resources from an influx of people moving just to claim benefits.
Oh, absolutely. And the legal guides emphasize that navigating this friction requires understanding the single most important distinction in this entire area of law.
Okay, what is it?
It's the difference between bona fide residency and durational residency penalties. A state is fully permitted to require bona fide residency. They are totally allowed to ask, do you truly live here? Are you genuinely domiciled in our state with the intent to remain?
This goes back to the out-of-state tuition reality we mentioned earlier. A state university system funded by local taxpayers can absolutely say, if you want the heavily discounted in-state tuition rate, you have to prove you actually live here and intend to build a life here, not just rent a dorm room for 8 months and leave.
Exactly. Validating actual residency is perfectly constitutional. The state can require you to show a local lease, get an in-state driver's license, or register to vote to prove your bona fide intent.
But a durational penalty is different.
A durational residency penalty is fundamentally different. That is when the state asks not if you live there, but how long have you lived here.
That feels like a subtle shift, but I'm guessing the legal consequences are massive.
They are. Imagine a state telling a newly arrived family, welcome, we agree you are genuine residents, you signed a lease and got local jobs. But because you just crossed the border last week, you have to wait 1 full year before you can access full state welfare benefits.
Oh, I see.
Or you must wait 6 months for basic state medical coverage.
Going back to our bouncer analogy from earlier, bona fide residency is the bouncer checking your ID to make sure you actually belong in the club.
Right.
A durational penalty is the bouncer letting you in, taking your cover charge, and saying, okay, you're a member of the club now, but because you joined 5 minutes ago, you have to stand in the corner, and you can't have a drink for 6 months. It is literally a penalty for being new.
That is exactly what it is. And the Constitution views that penalty on your basic necessities, like welfare benefits, non-emergency health care, or your right to vote in local elections, with extreme suspicion.
I would hope so.
Yeah, when a state places a durational waiting period on a vital government benefit, the courts subject that law to strict scrutiny, which is the highest, most unforgiving level of judicial review. The state must prove it has a compelling, unavoidable interest in enforcing the wait time.
And let me guess, saving money isn't a good enough reason.
You guessed it. Saving state money is almost never considered a compelling enough excuse to violate a fundamental right.
The philosophical reasoning here is really that the United States is a single, interconnected nation. If a state punishes people just for migrating across an invisible line, they are actively restricting a citizen's fundamental liberty to seek a better economic or social life within their own country.
Very well said. Now, the courts do allow short durational waiting periods for purely administrative purposes, like maybe a 30-day wait to register to vote, just so the state has time to process the paperwork before an election.
Yeah, make practical sense.
Right. And the courts allow longer waiting periods for non-vital, what they call portable benefits, like waiting a year for in-state college tuition or a year to get a divorce in a state court, because you aren't going to starve or die without immediate access to those specific things.
Yeah. Okay, so there is some nuance.
There is. But long penalties on basic human needs or fundamental political rights are squarely in the constitutional danger zone and will almost certainly be struck down under the right to travel.
Okay, so what does this all mean? You now essentially have a mental checklist for navigating state borders based on these mastery guides. If a corporation is facing discriminatory state laws, you know they are locked out of the Article 4 Human VIP Club.
They get turned away at the door.
Yep. So you have to look to the Dormant Commerce Clause and see if the state is spending its own money. But if you, a natural flesh and blood person, are charged exorbitant fees to practice your trade or access the courts in a neighboring state, you have Article 4 privileges and immunities on your side.
provided the state can't prove you are the specific source of a local crisis.
Like the whole scapegoat test.
Yeah.
And finally, if you pack up your life, move across the country, and your new state tries to make you wait a year for basic public benefits, just because you're the new kid on the block, your fundamental right to travel is being infringed.
And while our deep dive today into these constitutional doctrines is strictly educational prep and definitely not legal advice for your specific situation, analyzing these guides really is a masterclass in understanding how the gears of American federalism actually work.
It really is.
The founders designed a system that balances a state's sovereign right to govern its own territory with the absolute necessity of maintaining a unified mobile populace.
It makes you realize how intentionally the system was designed to foster a national identity. But as we wrap up, it makes me think the Constitution built all these incredible protections for the pursuit of a common calling and interstate migration based on a very physical 18th century world.
Oh, for sure.
It was a geographic reality where you had to physically cross a border with a horse or a moving truck to work or live. But today, in an era of remote work, you might live in one state, but fundamentally work in another entirely through a screen. You never physically cross a border, but your economic presence does.
That brings up a huge modern legal gray area.
Right. How will these ancient geographic concepts of domicile and borders hold up when a state tries to tax or restrict a purely digital worker? Something to think about next time you log into work from out of state. You might not be driving down the interstate passing that welcome sign, but your data is. Are you still protected? Thanks for joining us on this deep dive. We'll see you next time.